on the women's median earnings. So this is an important issue. And today we are joined by two experts who will be going into all of this more. So we are joined by Jenny Lamb, who is a policy officer at Shelter, and we'll be discussing how evictions and homelessness impact women. And also Eleanor Solomon, who is partner and housing specialist lawyer at Anthony Gold Solicitors, and we'll be discussing sex and gender-based discrimination in private renting. So the webinar is going to be structured. So we're going to have two presentations. Eleanor and Jenny will both be giving a 20-minute long presentation, and then we will go to a Q&A at the end. So if everyone could put their questions throughout the presentations into the Q&A box, then we will come to them at the end. Thank you. And so first we will head over to Jenny.
Rosie, I'm sorry, we're just having a small technical issue trying to get Jenny on the line. So
Okay.
we may have to just delay a couple of minutes while we get her on.
Fine, that's fine. Okay, so we've just seen Generation Rent have just said, can Eleanor and Jenny please identify themselves on the chat? Sorry about this, everyone. We will be on track in just a minute.
Right, I hope I can be heard now. Sorry for the delay there. My name's Jenny. I'm joining you from Shelter, and yeah, apologies there for that delay. I'm going to just quickly jump on and share my screen, if that's possible, so I can pop this presentation on. That's all right.
Yeah, of course.
Lovely. Okay, thank you. Okay, so I hope everyone's able to see these slides here.
Yeah,
just give
can
us
see
a
them.
fab. Thank you very much. So sorry, after that really shaky start, let's get going.
Yeah.
So thank you very much for having me. My name's Jen. I'm policy officer at Shelter. I work in the in the private rented sector. Now I have a background in advice, so this is a great seminar for me to be part of, I hope, because I'm doing a bit of policy and a bit of advice in this session. I do have quite a lot of ground to cover, so I hope I can get through everything without overwhelming anyone. But the key thing really to remember is that if any of these issues are familiar to you, if you're worried about eviction or homelessness, then do have a look at our website or use our web chat service. You can call us on the emergency number that's also on the website. So if at any point you do feel like you're worried and you could do with seeking advice, that's the first thing that I would always suggest to anyone. So just to start, I want to talk about why women are leaving privately rented properties. And at this point, I am saying leaving rather than being evicted from, because I'm going to go on to talk about eviction specifically. But with women's experiences, there are situations where leaving the home isn't exactly a free choice, but it isn't necessarily the result of an eviction either. I'm going to talk a little bit about both. So a lot of the statistics that I'm going to be talking about this evening are based on our tenant and landlord survey, which was done in 2021. We do this tenant and landlord survey every 2 years, and it gives us a load of really good data that we can kind of have a look at the lay of the land. In that survey in 2021, we identified kind of 2 key themes that emerge when we're considering women's experiences of eviction or otherwise leaving a private rented tenancy, which are useful in understanding the particular issues that women face in private renting. And these are housing conditions and affordability. I will speak about domestic abuse, and I'll speak about that separately, because although it wasn't a theme that emerged strongly from our tenant and landlord survey, it is obviously something that predominantly affects women, but it might not necessarily be a private rented issue, because women who are forced to leave the home as a result of domestic abuse could be leaving any kind of home. It might not necessarily be a private rented home there. So just to explain why I'm talking about conditions and affordability to start with. So women who responded to our private renters survey cited the main reason for leaving a tenancy was actually moving in with a partner or moving to a better neighbourhood or a more pleasant area. There are also reasons such as, mutual agreement, as in the tenancy was only ever supposed to be for a fixed period, wanting to move to a larger property, or that their previous accommodation was in poor condition. Now, we know that we found that women are more likely than men to be living with poor conditions that have gone unresolved. So if they'd moved into a property expecting the landlord would fix it, they often have to just endure those conditions. We've also found that women are more likely to have raised a complaint about poor conditions. And we do know from further research conducted by YouGov for us between February and March in 2023, that research found that people who complain to their landlords are 2.5 times more likely to receive an eviction notice as a result. So if you have more women living in poor conditions, more women complaining about poor conditions, then you can kind of expect that eviction notices are likely to follow and are likely to predominantly, or at least disproportionately, affect women. Women do report that poor conditions have a negative impact on their health, their children's health, and their general quality of life as well. Just looking over to the other side of the screen there at affordability, this emerges as another key theme in determining whether women can keep hold of their private rented properties. When asked if they could afford a 10% increase on their current rent, 47% of women said they couldn't, and compare that to 37% of men who said that they could. We know that rents are soaring and just going up and up all the time at the moment. back in 2022, in kind of autumn 22, 1 in 3 private renters in England had their rent hiked. So if women are bearing the brunt of, if the rent goes up, not being able to plug that gap and pay the new rent, then we know that women are going to be most adversely affected by the current conditions that are pushing rents higher and higher. We know that women are on average more likely to be relying on some form of benefits to contribute towards their rent compared to men. And 69% of women had said that they would worry about finding an affordable place to live if their relationship broke down. So reliance on benefits or reliance on a partner is something that that affects women more notably than men in the private rented sector. We also know that because women are on average more likely to be in receipt of benefits, the local housing allowance was frozen at 2020 levels, and since then, of course, rents have gone up. The local housing allowance is meant to cover the bottom third, the cheapest third of local rents. It now no longer does. So this is another kind of thing that's really heating up problems, particularly for women who may be dependent on benefits to pay all of their rent, and just makes it a really kind of a hostile environment really to be in at the moment. So moving on to thinking about why women are being evicted specifically, because I was talking previously about why women might leave. It might be to escape poor conditions, or because they can't afford a rent increase, for example. But looking now about why in particular women are facing eviction. Now, the overwhelming reason given according to tenants that we surveyed, is that the landlord wanted to sell the property, or the landlord wanted to move in themselves, or they wanted to move someone else in. That's according to the tenants when we asked them what was the reason that you think you were handed an eviction notice. That picture does change a little when we ask the landlords, because we run a landlord survey concurrently. And 56% of landlords told us that their main reason for serving an eviction notice was because the tenant had fallen into rent arrears. And that kind of harks back again to if affordability is one of the main issues that is affecting women in the private rented sector, and rent arrears is one of the main reasons that landlords are going to serve an eviction notice, that makes it a specifically difficult issue that women have to navigate in particular. It's really difficult to find what the real answer is. Is it selling? Is it rent arrears? Because it's not straightforward to manipulate stats in that way. And even the government homeless statistics are incomplete, because currently landlords are not obligated to give any reason for eviction. So what I'd like to talk about really quickly, because I'm aware that with the late start, we're running out of, I'm going to run out of time, is Section 21 notices in particular, because these can be really difficult to essentially defend yourself against. If you're worried about getting an eviction notice, this is what to watch out for, and this is what to do next. So the first thing, if you receive a Section 21 notice, is to make sure the notice you have been given is valid. If it's invalid, it cannot be used to evict you. So just listed out here are some of the things that you would need to consider or need to have a look into to see if you have a valid eviction notice. The only way to stop a Section 21 notice, or even to delay a Section 21 notice, is if the landlord hasn't done any of these things and that would ultimately invalidate the notice if they hadn't done one or perhaps all of these bullets on the white side of the screen there. So what we would suggest you do, don't delay. if you are a bit overwhelmed with the situation, it's a scary situation to be in, get advice straight away. Come to someone like Shelter or another homeless charity that you've heard of, just to get some advice. There are things that you can reach out for help with. If you're in rent arrears, for example, you can get debt advice. You can apply for something called Breathing Space, which is a government scheme that gives you a bit of time where your creditors can't chase you for debts in order for you to get back on your feet. You can apply for grants, and we would always recommend you check your benefit entitlement as well. If you are faced with a rent increase, you can always negotiate with your landlord. That is always an option for you. And you can apply to the First Tier Tribunal to challenge the rent increase, but do be aware that if your landlord is proposing to put the rent up, but it still is below market rate, then it can actually go up as well as down. So you do have to really consider and do take advice on that. In terms of poor conditions, we would recommend that you contact your local council's environmental health team, so that someone can come around and inspect and possibly even serve the landlord a notice which would protect you from eviction for 6 months following that notice. And that's to protect you from revenge evictions if landlords are unhappy that you've been to the council to complain about your property. I might just do a quick time check now, if that's all right, because I don't want to run into the next.
So we've just to let you know, Jenny, we have planned for a bit of extra time. So don't worry, you don't need to rush through your presentation. There is time.
Fabulous. Thank you so much.
That's all right, don't worry.
Cheers. Okay, so the next area I'd like to talk about is homeless assistance that people can expect from the local authority. And when I was an advisor, this was kind of our bread and butter, and most of the time that we would spend is speaking to local authorities and trying to assert people's rights for them. So I'm going to, first of all, just give you a very brief look at who is presenting as homeless, essentially, and what the kind of household composition is at the moment, just to give you an idea. So you can probably see that single parents with dependent children applying as homeless, it does tend to be women. But if you look at single adults just on their own, there's an awful lot more men applying as homeless than women with children. Still, you know, these numbers are significant, but that's just the kind of, you know, the kind of makeup that you're getting of families applying as homeless to their local authority. So on the second box, just down at the bottom, there's the figures around people applying who are pregnant, or people applying as a result of having to leave their property due to domestic abuse as well. So just wanted to give just a flavour of how many people we're talking about here, how many people are facing homelessness right now. We are hitting records in terms of homeless levels, and particularly homeless families in temporary accommodation. So in this section, this will be very advice driven. I want to talk about what happens when people are served with an eviction notice and approach their local authority, and what you need to, how you can kind of hold your local authority to account, because sadly, you do need to do that, we have found. So when you approach your local authority, you're homeless and threatened with, homeless or threatened with homelessness, and you're eligible for assistance, you're automatically owed the prevention or the relief duties, and they essentially say what they do. They do what they say on the tin. So prevention, the landlord, the local authority gets involved early doors to prevent you becoming homeless in the first place. Relief duty, that is when you are currently homeless and the local authority are stepping in to try and relieve your homelessness. So that's the theory. The next question that the local authority will ask is, are you in a priority need category? If you are, you will be eligible for emergency accommodation. Again, does what it says on the tin. That's where you stay when you have nowhere else to go and you are in particular need of accommodation. I'll explain what priority need means in a moment. And then the last couple of tests follow on from everything that's come before. If you have a local connection to your area, so you've lived there for a certain number of years or you have family there, and you haven't made yourself homeless intentionally, so you haven't done anything to bring about your own homelessness, then you will be owed what's called the main housing duty. And that means that you are owed longer term support, essentially, and temporary accommodation, which is, again, longer term. It's like longer term emergency accommodation. Emergency, if you think about it as if it's a hostel or a hotel or a B&B. The temporary accommodation is essentially a house owned by the council, let out to people as a bit of a stopgap before they try and move you on into more permanent accommodation. So that is the theory. That's how it should work. It doesn't always work. So the first thing I'll do is I'll talk about priority need. There are certain things that confer a priority need straight away. That is having dependent children or being pregnant or being a victim or a survivor even of domestic abuse. And that is the primary reason for your homelessness. That plus if you're homeless due to fire or flood, that will always give you a priority need. There are other vulnerabilities that can confer a priority need, but that you need to be able to prove those to the authorities, either with medical evidence or something similar. If you've spent a lot of time in prison, for example, that can confer a priority need, but it's done on a kind of discretionary basis. But I'm going to focus on dependent children, pregnancy and domestic abuse, because these are the issues that predominantly are affecting women. So once priority need has been established, the applicant is owed emergency accommodation and can be considered for the main housing duty as well, which means they will be helped in the longer term. As I said before, this doesn't always happen, so I just wanted to talk through some of the main problems and pitfalls that can arise even when priority need has been established, because it's rarely smooth sailing. And this is a know your rights webinar, so I thought it'd be a good place to talk about what to do when you think you're being treated unfairly. So dependent children, this is we know that there are lots of families in temporary accommodation at the moment with children. 35% of the people in temporary accommodation are single women with children. So you would have thought that this was quite an obvious way of proving that you have a priority need. It's one of the most black and white reasons that would confer a priority need, but it can still you can still face some barriers from the council. So if the council are asking too early about local connection or intentionality issues and they don't provide emergency accommodation, that's what we call, it's a form of gatekeeping, which is when councils are looking to protect their kind of resources and their time. We have found that people are often we call it playing, ping pong between local services. So the housing may point you to social services may point you to housing. So people do kind of get swept up in being passed between departments. There are certain rules. So just an example here is if you have dependent children, you shouldn't be in a B&B for more than 6 weeks. And sometimes the council will tell you that emergency accommodation or temporary accommodation just isn't available. There's a shortage, we can't put you anywhere. There's also issues around suitability. Maybe the conditions are poor or the distance is too far from schools or local support networks. So all of these can be challenged. What we would always say is if you feel you're being treated unfairly, do seek advice. Housing law is really fiddly, and sometimes you are, if you're facing these situations, you're going through some of the most stressful and upsetting days of your life. So do reach out for support on this. If you are offered accommodation by the council we would always tell you to accept it, even if you don't think it's suitable, and then ask to have the decision reviewed. This means you've secured the roof over your head. The council can't essentially end the duty for you not complying with their requests, but you can challenge it on the basis of suitability. Similarly with pregnancy, you're owed a priority, you have a priority need, regardless of the duration, regardless of how long you've been pregnant. You have to establish the pregnancy, so you have to provide proof, a letter from a doctor or a midwife. Again, similar issues around front-loading inquiries that should come later down the line are ones to watch out for, because it could, if the local authority think you don't have a local connection, or they think you've made yourself intentionally homeless, they may try and front-load those inquiries so that they don't have to immediately offer you emergency accommodation. You have to look elsewhere. It's not something they should be doing, and it's something to definitely look out for. Again, availability and suitability of emergency accommodation and temporary accommodation can be an issue, and it can be challenged. One thing that's really difficult with people who are pregnant is that the size or type of accommodation that may be considered suitable for a pregnant person might not be for a newborn. So it's very short-term thinking that councils can kind of fall into, because they are struggling to find places to place people. So sometimes people end up in an accommodation that wouldn't be suitable for a newborn during the duration of their pregnancy, and they're not entirely sure what's going to happen next. So it can be a very stressful place to be. Domestic abuse. So if you are a survivor of domestic abuse and you've been made homeless as a result, you can apply to any council, provided it's safe for you to do so. The things to look out for here is domestic abuse is in a way quite tightly defined. It doesn't have to be violent, but sexual abuse or harassment from a person unrelated to you is not included. So if you are a victim of violence and harassment in your own home, but it's not a partner, or it's not a husband or a family member, then the council might not necessarily, they wouldn't look at that as domestic abuse, and that wouldn't give you a priority need. The council can look into your situation. They can't demand evidence of domestic abuse before they accept your homeless application. So they can't demand to see a police report or a crime reference number. So that's something really important to know. They can't approach your abuser. They can ask you for ID, but the guidance, the code of guidance that they have to follow does say that often survivors of domestic abuse do have to leave situations very rapidly and don't always have access to all the documentation they need. The similar kind of front loading of issues of a local connection or intentionality inquiries apply as well. But just to say here, you can be referred out of area if the council feel you're not safe in their borough. If you feel your application isn't being taken seriously, then I'd recommend you have a look at the code of guidance to remind councils of their obligations, or speak to someone like Shelter who would be able to support you through that. And just in the last couple of minutes, I just wanted to talk briefly about the difficulties that women face in finding a new private rented home. So imagine you've had the eviction notice, you've been through the homeless process, and now you're moving on from either emergency or temporary accommodation, and you're trying to find somewhere else to live. Now, I know that there's going to be another presentation specifically on discrimination that women face in the private rented sector, so I'm not going to go into that in too much detail, but I thought it would be helpful to kind of talk a little bit for a couple of minutes about a couple of campaigns we have ongoing at the moment that are really relevant, especially to women. So we've launched an end income discrimination campaign, because we know that affordability is a massive issue for everyone right now, and especially for women. So we have people, 15% here, it says, of private renters unable to rent somewhere because they couldn't provide 2 months rent. 25% couldn't find a UK-based guarantor or a guarantor that fit the criteria. Women also face discrimination because they have families, they have kids with them, and 1 in 14 families haven't been able to rent somewhere because they have children. So we've wrapped all this together. We're using the Renters Reform Bill, which is currently on its way through Parliament, to try and strengthen renters' protection against discrimination. And the other campaign that we have running right now, particularly relevant to women, is calling on the government to end the local housing allowance freeze and restore housing benefit, so it actually does cover the bottom third or the cheapest third of local rents, which is exactly where it's supposed to be. I'm sorry it's been a bit of a whistle stop. I hope some of that was useful. If there are any questions, then please, I'm very happy to answer those at the end of the session. So thank you very much.
Thank you so much, Jenny. That was really helpful, and yeah, really shining the light on the ripple effect of poor conditions and affordability that has on women's ability to access safe and secure housing. So thank you for such clear advice on those issues. And it's also great to hear what Shelter's doing in that space as well. Our next presentation is from Eleanor. So yeah, I will hand it over to you, and it will be on gender and sex-based discrimination. So yes, thank you.
Thank you. Let me just work out how to share my screen.
Just to add as well, sorry, that the questions will all be at the end. So there's a Q&A box. So if people could just add any questions there, we'll get to them after Eleanor's presentation as well. Thank you.
Okay, can you see that? Wonderful, lovely. Okay, so I'm going to talk, mine's a lot more specific and a lot more law-based and a lot more technical. Hopefully I can keep everybody interested, but I'm going to talk about sex and gender-based discrimination in housing on a more one-on-one type situation rather than an overview. So firstly, just to say get to the next slide. There we go. I work in civil law. I don't work in criminal law, and I'm not a particular expert in criminal law. But lots of the things I'm going to talk about obviously are primarily a criminal offence, and you should go to the police if your landlord is threatening you, harassing you, definitely assaulting you, and also spying on you, which is unfortunately something that I see relatively often in this context. I think I've seen in the chat already somebody saying that the police are unhelpful. And the police often are unhelpful, but it's a good idea to go to the police anyway. Firstly, because they might not be unhelpful, and sometimes they might resolve the problem. Even if they don't end up prosecuting the landlord, they might have a harsh word or something, and from time to time everything goes right, and that might do the job. But secondly, even if the police unfortunately are not very helpful and it doesn't go well, it's an excellent source of evidence if you have made a complaint to the police, if you need to make a later homeless application, or if you want to take some kind of action against your landlord. So it's definitely worth doing, even if you've had a bad experience and you feel put off by the idea. But assuming that you're not going to the police and that you're taking a civil remedy, that is to say a kind of a one-on-one action, suing somebody between you and your landlord, the main law that you'll be using is the Equality Act 2010. And the Equality Act 2010 stops people discriminating against other people, but only in very, very, very specific situations. And it's something that it's a law that is very misunderstood by lawyers as well as non-lawyers, because the situations are really so specific, and it's not intuitive really. So not everybody is protected from discrimination. Only people with certain protected characteristics, as they're called, are protected from discrimination. And here they are. So you'll see that sex is one of them. And importantly, sex rather than gender is the way that it's defined in the Equality Act. That is to say, It's a kind of biological way of defining it, which is slightly controversial amongst some people, or welcomed amongst others, but that's what the law says. But there are other protected characteristics that might be relevant in this context of sex discrimination in renting. One of those is age, because there can be discriminating against people who have children, for example, and that might be unlawful. And another one is marriage and civil partnership, or crucially pregnancy and maternity. So in general, discrimination against anybody with these protected characteristics for a reason to do with this protected characteristic isn't allowed, but it unfortunately is nowhere near as simple as that. And I'll go on to kind of some of the specific examples of what might come up here. So the most obvious one, and the kind of scenario that everybody thinks of when they think about unlawful discrimination, is direct discrimination, which is a person discriminating against another person because of a protected characteristic. So somebody treating somebody less favourably than they would treat others. So that's probably what most people think of when we think about discrimination. And what I've put up here is a link to a case by Shelter, actually. This case by Shelter didn't use the Equality Act, as far as I can see. They used the Property Ombudsman's rules, but this was finding that basically policies against letting properties to children was unlawful because it broke the Property Ombudsman's code of conduct. But I think that is also an example of direct discrimination, and that's a really, really excellent case. And that's such a common scenario that letting agents and landlords say, sorry, no, we're not going to let to people with children. That is just unlawful, and it is very, very common. And this, this is something that could and should be raised, and we'll come on a bit later to how you might actually do that in practice. But that is unlawful, especially if the property is completely suitable for children and it has, more than one room, etc. So it's not only landlords who are not allowed to discriminate under the Equality Act. In fact, nobody is allowed to directly discriminate, whatever their status, but letting agents have a sort of specific section in the Act, not for letting agents in particular, but under the heading of service providers. So service providers, as letting agents are not allowed to refuse services based on protected characteristics or to harass or victimise those they're providing a service to. So if a letting agent is harassing or victimising somebody based on their sex or based on another protected characteristic, rather than just being a horrible person in general, then that's unlawful under the Act. And likewise, refusing services based on protected characteristics is not allowed. So if a letting agent, rather than the landlord, is saying, no, we don't deal with anybody with children, A, that's an age discrimination issue, and B, most likely somebody with children looking to let is going to be a woman statistically, so either way, or also pregnant people as well. So if a letting agent discriminates against you, you can make a complaint to the letting agent themselves, which might not be much use, but then you can escalate that back to their redress scheme if no action is taken, and then action should be taken against the letting agent, and letting agents should be a member of a redress scheme, and you can find that on their website. And if they're not, you can make a complaint to Trading Standards, who should be able to take some action. So there is a route in relation to letting agents. And then there are specific rules relating to landlords, basically, because there are rules about premises and managing premises. So same thing again, you're not allowed to discriminate on the terms of letting premises. So that means you're not allowed to say, I'm not going to let property to you because you have a family. Also means I'm not allowed to charge you more rent, for example, because you have children, because that would be a term of letting. Or you can't say even I'm going to take a higher deposit from you because you have children, because that would also be a term of letting based on a protected characteristic. So you can't change the terms of the contract based on somebody's protected characteristic. So a landlord or agent could say, for example, I'm going to charge you a higher deposit because you've got a dog, because having a pet isn't a protected characteristic. But you can't say I'm going to charge you a higher deposit because you have a child, because that potentially is. And a landlord can't harass anyone who occupies the premises or applies to occupy the premises. So as we'll come on to later, harassment is a kind of separate law in itself that you're not allowed to do, but specifically you're not allowed to do harassment based on somebody's sex or pregnancy or age or anything like that. So specifically, somebody who manages premises can't discriminate against people by the way they allow to use them. So they can't put specific terms on them. They certainly can't evict somebody or take steps to evict somebody based on their protected characteristic. So really, really frequently, people call my firm with inquiries saying, my landlord's trying to evict me and they're kind of harassing me and I want to sue them for this. And in most cases, even though it's really, really horrible to be threatened with eviction and you do feel very harassed in that scenario, that it's not unlawful to try and take some steps to do a lawful action, such as lawfully evict somebody via court. But if the motivation for that eviction is something to do with sex or discrimination or another protected characteristic, then that is unlawful. And then that can be used to A, defend the possession proceedings to stop the eviction, and B, potentially take a counterclaim to get some money. So say, for example, somebody became pregnant and the landlord found out, and then the landlord served a Section 21 notice. If you could prove that the motivation for that serving of a Section 21 notice was the pregnancy, which would usually be quite hard to prove because landlords aren't usually quite so stupid as to tell you, but sometimes they are. If you could prove that, then that would be a defence to the possession proceedings, because that would be an unlawful act in seeking to evict somebody. So to go back to the act here, the landlord can't subject the protected person with a protected characteristic to any other detriment based on that. So basically, you just can't do anything bad to somebody that you wouldn't do to somebody else based on their protected characteristic. And you can't harass anybody who occupies the premises or anyone who applies to occupy the premises. I'll come on a little bit later to what harass actually means. So how do you use the Equality Act? So you can sue to get damages, which is compensation for pain, suffering and inconvenience, which is in general about a range of bands from about £990 to about £49,300 plus any actual financial losses that you've had as a result. You can get a declaration or an injunction to change the behaviour, so to stop the landlord trying to apply a different term to the tenancy or trying to evict you, and it can be a defence to possession proceedings. Now, I'm afraid none of this is straightforward whatsoever. Equality Act claims are really, really, really technically difficult, and legal aid is available for them, and it's quite clearly available for them where it's linked to something like a defence to possession proceedings. But for a standalone claim for damages, it's only going to be available if it's very much linked to, in the housing context anyway, if it's linked to a housing case and it's worth quite a lot of money, because you have to prove basically that you're going to get 3 times as much money in compensation as the legal aid costs are going to cost, which is often not the case because these cases are really difficult and complicated and take years. Or that you're asking for a declaration or injunction, which is going to do something like keep a roof over somebody's head or prevent them from being homeless. So to be completely honest, whilst all this law is available, it's not something which is very frequently used. I've run a few Equality Act claims in the homelessness context myself, and I think it's relatively rare. It's difficult to know what case law is out there, because unfortunately when discrimination or the Equality Act comes up, very, very frequently the defendant will want, as a condition of settlement, there to be a non-disclosure agreement or confidentiality agreement. So it means that we don't get to know what case law is happening a lot of the time. And often people would agree to that confidentiality agreement, A, because it's about something quite personal that they don't particularly want everyone to know about anyway, and also because honestly, after years of litigation, you just want the case to be over and, leave it. And it's not anyone's biggest priority, which is a shame. But just being realistic, it's not very likely in most cases that you're going to sort of issue your own Equality Act claim and that it's all going to go very well. But what you can do is mention the Equality Act, especially if you have a reputable landlord or agent's representative body to complain to, because it is something that those people should know about and which should raise significant alarm bells if there has been discriminatory behaviour. Now, outside of the Equality Act, where might the law come into this kind of landlord and tenant discriminatory relationship? So trespass is a really big thing that I see happening. I advise quite a lot of student tenants. They're often vulnerable just by being young, and lots of them are women. And it's not at all unusual for landlords or agents to just be sort of wandering into their bedrooms in shared houses, often for some kind of reason, like they're trying to show another potential tenant around, or sometimes maybe a more sinister reason. Whatever the motivation, your landlord cannot come into your house at all if that's what the contract says, that there's no kind of shared spaces, or if you're letting just a bedroom, the landlord can't come into the bedroom without you agreeing to that, basically. Even the tenant has an obligation to give access on 24 hours written notice, but if they don't give that access, the landlord can't just then open the door with their own key and walk in. The tenant has to agree to somebody coming in and invite them in. It might be that if the tenant says no and never allows access, then that's a breach of their tenancy agreement, but the landlord's remedy there would be to go to court and apply for an injunction for the tenant to give access. The landlord cannot just come into somebody's home. That is trespass, and you would have a claim against them. And then there's a kind of overlap sometimes with harassment and then unlawful eviction. So let's talk about harassment first. Harassment and unlawful eviction, there's two acts, and they both have a kind of similar setup in that they provide a civil and a criminal remedy. So in the acts, there's a similar kind of explanation of what you're not allowed to do, which is harass people or unlawfully evict them. And there's a criminal remedy, which means it's a criminal offence, and the police could be involved and could arrest somebody, and they could go to prison. And also there's a civil remedy, which means if the police don't do anything, you can sue them yourself to get a remedy. So what's harassment first? Harassment and also stalking, which is in the same act. Harassment is pursuing a course of conduct. That's the first really important bit, because that means a one-off act isn't harassment. It might be an assault, it might be something else, but it has to be a course of conduct. It has to be more than one thing, and probably more than two things, probably at least three acts that are done to be harassment. So they don't have to be all the same act, but they could be something quite minor in themselves, but when the kind of whole picture is built up, it's a lot more serious. So some examples I can think of are landlords spying on tenants, which is something that kind of creepily with with the availability of video software that comes up quite a lot. That's harassment if it's not a one-off thing. Or using words or language which is really unpleasant, sending lots of emails, bothering them, hanging around outside their flat for no reason. So the course of conduct amounts to harassment of another, and which he knows or ought to know amounts to harassment. So that means the landlord either knows that it's harassment, or really they ought to know, as in anybody viewing the scenario would know that that's what it is. So if the landlord, for example, was sending a series of legal letters to the tenant about, can you please move your bike out of the hallway? Can you please, I don't know, just lots and lots of requests, even if it was quite over the top. If a third party looking at that wouldn't say that's harassment, but the tenant feels they are harassed, then that's not harassment. If not everything that you don't like that happens consistently is harassment. It has to be looked at by an independent third party and thought, yeah, that's harassing behaviour. And then kind of an overlap with unlawful eviction. So unlawful eviction being on the face of it where you evict somebody not by taking them to court, but by either classically chucking them out and changing the locks, or with intent to cause that person to leave, does acts calculated to interfere with the peace and comfort or withhold services. So that would be something like turning off electricity or services, or harassing them, just continually harassing the tenant and bothering them and shouting at them and asking them to leave until they do. And that's something which is neither the harassment nor the unlawful eviction scenarios are exclusive to women, or indeed to any protected characteristic. But with harassment in particular, I guess that's a context that I would see coming up in the landlord and tenant world, with landlords harassing especially very young female tenants, probably in shared accommodation quite a lot of the time. And that is the end of my slideshow. So a whistle stop tour. I will stop sharing my screen. You can work out how. And right, sorry, here we go. Stop share. Wonderful.
Thank you so much. That was such clear explanation of such complex materials. So yeah, thank you so much. I feel like we've got a lot of questions in the Q&A box as well. So we'll start going through them if that's okay with everyone. And I think, well, firstly, there was a question that was brought up during the actual one of your presentations, and so I thought we could start with that. But what should we do when the police stands by the criminals is the first question. I will first go to Eleanor to answer that one.
That's not easy, and as I say, unfortunately, it's not really my area of expertise in criminal law. I mean, it might be, as I say, that you have a civil remedy and that you can basically ignore that whole thing, and not, depending on how serious the offence is that you want to be the police to look at. So it might be that you can kind of almost ignore that, not rely on the police at all, and pursue your own civil remedy under one of the laws that I was just talking through there. You can always make a complaint to the police as well, but that's something I just know about as a layperson. Really, I'm not an expert in criminal law, unfortunately.
Jenny, do you have anything to add there? Thank you, that was really helpful.
Yeah, maybe a couple of things. So if you're talking specifically about landlords illegally evicting, quite often we have had people call our helpline when I was an advisor to say, I tried to call the police, but they told me it was a civil matter. But it's not, it is a criminal matter. So you've got some poor person in the middle with a landlord attempting to illegally evict them on one side and the police saying, this has not got nothing to do with us on the other. We would direct people to our website. There is a whole section on there on what to do if the police aren't helping you. There's a letter on there that you can kind of read out to them word for word to explain to them why this is a criminal matter and the police need to get involved. So that's maybe the first thing that I would say. In terms of from an advisor point of view, what can you do when the police are standing by the criminals? It is a really difficult situation. All I can suggest is document everything as much as you can. Make sure you have evidence, and I guess follow the processes and procedures as best you can. The other thing that you might be able to do, if it is the landlord rather than a neighbour in a private rented property that you're concerned about, you could contact your local council, and they sometimes have tenancy relations officers who could get involved, kind of step in as a mediator essentially, and try and help you resolve that situation. So that's maybe a couple of things to go on, if that's at all helpful.
Brilliant, thank you. That is really helpful. And I just want to say, obviously, there's a lot of quite emotive material that has been brought up and a lot of big issues, and all of the slides that have been shown will be sent out to everyone who's in this webinar. And yeah, I just want to make sure that there's all of the information that is being given will be given over to everyone as well separately. So the next question I was wondering was, are significantly more women or couples where the woman is the main or sole income earner, homeless due to the earning inequality. And so, Jenny, I was wondering whether you could come in on that one first. That's an anonymous question.
Yeah, so the figures that we've had, actually only in the last few days, most up-to-date government figures on homelessness, they would suggest that there's a lot of, we're hitting record numbers of homeless families at the minute. In terms of single homeless people, men do outnumber women by about half again. In terms of, are people homeless because of income disparity or I'm assuming the gender pay gap, I wouldn't have a really good answer on that. All I can say is pretty much as far as I said in my presentation, we do know that affordability is something that hits, just on balance, hits women harder. And that is, our focus tends to be on the fact that women are often, on average, more likely to be claiming benefits, and the gap that the benefits cap and the local housing allowance freeze leaves, and makes, you know, kind of when women have to kind of try and plug it by themselves. The other thing I would kind of say, so that's not really where our focus tends to be on the benefit recipient side of things, rather than kind of just differences in you know, essentially the gender pay gap, if I'm understanding the question correctly. The other thing about homeless statistics that's really difficult is even the most up-to-date ones from the government aren't going to show us the full picture, because they can only collect stats where they know somebody has been made homeless. There could be any number of reasons why someone doesn't approach the council if they become homeless. The council also could turn them away in you know, when they shouldn't have done, because we know that happens as well. And then they wouldn't be recorded. So the problem is actually a lot bigger than the statistics we have would suggest. So, and I'm only saying that is a bit of a non-answer, but I'm only saying that to explain why some very specific questions about the statistics like that, we would struggle to come up with a really good answer, because in all honesty, no one has really got the full picture of the extent of homelessness in this country.
Thank you. It's a very complicated issue, but I think that was a very comprehensive answer. So thank you. Eleanor, do you want to come in on that?
I don't really have anything to add. I would be purely speculating, I'm afraid. So I think Jenny's covered it really well.
That's completely fine. The next question is also an anonymous question. This is someone asking, saying they fell into rent arrears because the council refused to give them housing benefits from the very beginning, and they did not want to help them with the endangerment and violence. I'm wondering whether you could come in here, Eleanor, for that one.
What's the question? Sorry, I mean, obviously,
I guess they're wondering what they do if they've been refused housing benefits and then they've fallen into rent arrears because of that.
Okay, so if you're refused housing benefit, then you have a right of appeal. I don't know how long ago this was, or if it might be just sort of a bit late to do that now, but I mean, if you have been refused housing benefits, you can appeal, and there are still some organisations out there that can help you with that appeal, depending on where you live. And if you do fall into rent arrears because of that, you can also apply to the council for discretionary housing payments. And if it all goes too far and you are made homeless because of that, then the council may well say that you've made yourself intentionally homeless because of failure to deal with these issues, but that isn't necessarily the final answer. It really depends on the specific facts and why you're refused housing benefits and whether you were genuinely eligible for housing benefit or not. If you were refused it because you weren't eligible and you haven't paid your rent, then perhaps that decision of intentional homelessness would be upheld. But if not, and something else has gone wrong, then any kind of homelessness decision could be reviewed and appealed on that basis.
That makes sense. Thank you. Jenny, did you have anything to add there?
I do quickly, and it feels like it's a bit of a plug, to be honest, but the Renters Reform Bill that I mentioned during my presentation is on its way through Parliament at the minute. We're kind of pushing for it to be brought forward because part of it is related. Well, there's a change that the Renters Reform Bill is hoping to bring about in private renting, specifically when it comes to rent arrears and its relationship with benefits. So when people fall into rent arrears, sometimes it is to do with the dates not lining up between their rental payments and their benefits payments, or it could be to do with mistakes that have been made. So your benefits have been shut off and you don't know why, and a mistake was made with the DWP. There is a change proposed in the bill as it currently is to say that if your rent arrears are mainly due to a mistake or a delay with your benefits payments, then they shouldn't be counted as your arrears, or they shouldn't be counted towards your arrears. And that would really help a lot of people who maybe every other month have an issue with their benefits payments not lining up, or a mistake in their benefits claim. So if you want to get involved with that campaign, I'd really recommend you go over to our website and sign the petition on there to try and bring the Renters Reform Bill back to life, because it has somewhat stalled since it was first announced earlier this year.
Thank you, that's really helpful. It's encouraging to hear how new legislation could potentially help in some of these situations as well. And yeah, so the next question is also anonymous, and it's someone's wondering whether it would be regarded as making whether a tenant would be regarded as making themselves intentionally homeless if they refused a rent increase. They would have a good reason, as there's quite a lot of disrepair, so all of which the landlord has been told about this many times. So yeah, Eleanor, would you be able to answer that one?
The first thing to say is that you don't have to accept a rent increase or leave unless the landlord follows the correct procedures. So your tenancy agreement will have a specific rent in it. Sometimes the landlord will try and encourage you to sign a new tenancy agreement with a higher rent, and that's something that you don't have to do. So you can just say no, you don't have to leave, you don't have to pay a higher rent. If that's the way the landlord's going about it, you can just say no. If you say yes and you sign it, or you agree to a higher rent, then that will be binding on you. But if you don't have to. If your landlord serves a Section 13 notice on you to raise your rent, and then you don't appeal it, because it can be quite hard to appeal, because you'd have to prove that raised rent was higher than market rents, and quite often market rents are high. So if that happened and the rent was raised and you couldn't pay that higher rent, and then you became homeless, whether you were found to be intentionally homeless or not would be based on, was it actually affordable for you to pay that additional increased rent? Because if it wasn't, and you couldn't pay the rent, and then that's why you fell into arrears and became homeless, then you shouldn't be found to be intentionally homeless. Again, unfortunately, not to say that you wouldn't be, because councils often make wrong decisions, and it might be that you'd have to review that decision, but you shouldn't be. Disrepair was also mentioned. So if you have disrepair and your landlord's seeking possession proceedings based on rent arrears as the ground for possession, rather than Section 21 as the ground for possession, then you can do a disrepair counterclaim potentially, and that's something that you can get legal aid for. So what you're doing there is you're saying, okay, I may owe arrears of £5,000, but I'm owed £10,000 in disrepair damages, and therefore my rent arrears will be wiped out, and the landlord will actually hopefully end up owing the tenant money, depending on how it all works out. So that's a possibility. But if it was Section 21 that the landlord was using to evict, then that wouldn't be a defence that would stop the possession proceedings. The tenant could still bring a disrepair claim, but it wouldn't stop the possession proceedings.
Thank you, that's really helpful. It's a very clear explanation. Jenny, do you have anything to add there?
No, that was really, really comprehensive. So yeah, no, I think that's everything. Just to kind of reiterate something that Eleanor said, councils do make mistakes, and what my time as an advisor taught me is that a lot of the time they're not actually afforded, the kind of level of training and kind of investment as staff that that they should have had, or that they need to do a job that is as important as the one that they're doing. Councils are woefully underfunded, woefully under-resourced, and everyone has a hugely high caseload. So it can feel like screaming into the void at times, and they, as Eleanor said, they do make wrong decisions, and sometimes they make those decisions in order to protect their resources as well. So in situations where you feel like you're being treated unfairly, do seek advice, because it can really help to have an advocate speaking for you.
Thank you. That's a really helpful point. Thank you. So I guess there's quite a running theme of a couple of questions about people basically not getting responses from the organisations that they are reaching out to. So whether that be the council, the environmental health, or the antisocial team. And so I was just wondering whether on behalf of all of those different organisations and those questions that people aren't getting the responses that they need from, what is the sort of best way forward if you just simply aren't getting a response? Is there any advice that either of you would be able to give here, Jenny or Eleanor? So it's a difficult question. I have no idea what I do yet.
Well, so. From I suppose I can share some tips and tricks that I would use to get attention as an advisor, trying to bully councils on behalf of clients. So it's quite easy to find the head of housing's details or the CEO's details online. It's public information, it's available. So if I was not getting a response, that's what I would do. I would contact the CEO, and I would make a bit of a nuisance of myself. Not everyone's got the time to do all this. This is one of the things that is one of the biggest kind of injustices of this whole situation, is that the people who are the most pushed, the most stretched for time, and the most stressed are the ones that are having to now, play private investigator to try and, secure what they are already legally owed. There is something really distasteful about that. But before I'll get off my soapbox and just give the advice. So yeah, it's very easy to find CEO details, head of housing details. Have a look at that. You could contact your local MP. That's something that I would suggest as well. If you're being chucked between the different kind of services, sometimes, so for example, if housing are telling you this isn't our issue, then you might want to get in touch with social services. Sometimes because they don't want the case either, they might put some pressure on the housing arm of the council to accept a duty towards a homeless applicant, for example. I'm trying to think of what other kind of tips and tricks we would use. One thing I would say is a lot of the time people will try and call the main council, the number for the housing line, and they'll be told to submit a form, or you have to apply online or something like that. That's not true. That's another form of gatekeeping. A homeless application must be accepted, and it can be in any format. It can be an email, it could be a phone call, or you could go to the office in person. If someone is telling you you have to complete a form online, then that's incorrect. So I would, if you can, have a look online, try and find an email address and write up your situation, apply in writing, so that you have a paper trail of when you've been trying to contact the council. And aside from that, I would say to keep trying. It's good to have a record of all the times you've tried to be in touch, but you can't. Yeah, if it's going above, going above people is kind of the way that I found to get some attention. But it is really difficult when no one is responding, and you can feel very despondent.
Yeah, and just to add to that, make official complaints. That can either be online or just an email headed with the word complaint. Go through that whole complaints procedure. Often there's a stage 1, stage 2 and stage 3 procedure, and then take it to the Ombudsman. And the Ombudsman can deal with some kind of niche scenarios which aren't really a case that fits quite neatly into a legal action. So the Ombudsman are getting better and better and better at both making recommendations for councils to do better in certain situations, and for kind of more compensation than they used to. But it is worthwhile, and it is a completely accessible route if anybody in the council isn't getting back to you. And that complaint could be about some kind of terrible systematic thing, or it could just literally be, I have complained and nobody has responded to me. And that can be the source of a complaint. And yeah, otherwise it's very difficult. It's very difficult to get anybody in the council to respond. I find it too. I'm constant. Half my job is getting people in the council to respond to things, and it's also, there is a really, really difficult balance sometimes to be held just between being polite enough that people don't shut you off, but not being so polite that you get fobbed off easily. So it's almost a sort of a delicate skill that you have to do in sort of starting off every conversation. Oh, thank you so much for talking to me. What a pleasure. Oh, I know it's not your fault personally, but not sort of accepting being fobbed off. No, I need to speak to your manager. No, this is not acceptable. No, something has to be done. And local councillors as well as MPs can be really helpful as well. And that's me on the subject.
Oh, frozen. Oh, there we go. That's really helpful. I've definitely got some tips myself there, I think, if I ever need them. So I will just, sorry, 1 second. Yeah, so this is a question that's a more general question about going back earlier to the presentations, but why do women live with unresolved disrepair issues more often than men? So it's a bit of a broader question, and I was wondering who would want to come in there. Is that Jenny or Eleanor?
Yeah, I could jump in. It's, in some ways, I'm speculating a little, because the stats that I've got were really, they're directly from our tenant and landlord survey. So that's what we've been told by the people we surveyed, that's what we found, that women are more likely to be putting up with poor conditions, despite being, a bit more likely to complain about poor conditions. If I'm speculating, I would think that if women are more likely to live in households with children, it could be that the area is more important than the condition of the property, or not that it's more important, but that in order to keep kids close to their schools or local services, doctors, nurseries, all these things, then their choice, the kind of the breadth of the net they can spread and move within is narrower. They can't just leave for somewhere a bit cheaper, a bit further out, in better condition, because they may be tied to a particular area because of the needs of their family or their kids. It could also be that due to affordability issues, they're unable to make a move because inability to kind of put enough aside to save for the really high costs of just moving house, let alone the fact that if you move, you're more likely probably to be going into a more expensive tenancy, because since you moved, rents have likely gone up. So I would, if I am speculating a bit, I would say that they are two factors that would probably mean that women are more likely to kind of put up with poor conditions. It's being tied to a particular area and not having the funds readily available to make a move to somewhere more suitable.
I'm going to speculate as well. I didn't know that women were more like, I didn't know that statistic until Jenny just told us now, but I do a lot of disrepair cases, and I've probably acted for hundreds, if not thousands, of people in disrepair cases over the years, and probably about 80% of my clients are women. I would always assume that that's because I act mainly against social landlords, and women are more likely to have social housing than men are because they're more likely to have children. But contrary to what you might think, actually surveys show that social housing is in a better state of repair than private or even home-owned housing. It's actually in the best state of repair, which is quite shocking. So it's not that necessarily. I'm going to say something maybe controversial and unpopular, which is that sometimes I act on like a whole group of flats, everybody in a whole block of flats, and I pick up a lot of clients that I wouldn't otherwise have. And sometimes I pick up I find that flats with men in it sometimes are in better condition because men are more likely to just do the repairs themselves. Obviously they can't do the whole thing, but they are more likely to just do something that they're not supposed to do to make the flat in a better condition. But that is certainly not a statistical reason that you can quote me on, but that can be one reason. But yeah, I don't know why or maybe it's just a thing that women are more likely to report in a survey that their house is in disrepair, and that it may be something completely like non-conclusive like that. I don't know. It's very interesting though.
Yeah, it's really interesting. I also didn't know it before you shared that, Jenny. So yeah, thank you for sharing that. Thank you both for your speculations. They all sound like they have merit, to be honest. So who knows? Here's another question. This is also anonymous. It's someone wondering whether if you become pregnant, whether you have to tell your landlord, and what should you then do if they tell you that they don't want the child in their property. So I was wondering whether you could come in here, Eleanor.
No, you don't have to tell your landlord, but they might find out, obviously, because they might see you. And what should you do if they tell you they don't want a child in your property? Well, nothing at all. And if they try to evict you for that, then you should defend the possession proceedings with the aid of a solicitor if you're eligible for legal aid, or you can get one on the basis of that it's unlawful under the Equality Act. And I would be personally happy to act for anybody who is in that specific scenario if your landlord told you that they're evicting you for that reason. So to plug my firm, but it's usually an acceptable one in housing law when it's so hard to get a solicitor. You could come to Anthony Gold, or you could come to many other firms, and that would be a kind of almost a dream scenario, because usually landlords, as I say, aren't actually clever enough to tell somebody that they're evicting them because they're pregnant, because they're often clever enough to know that they shouldn't do that. But yeah, they're not often clever enough to know that they should not say they don't want a child in their property, or I don't know. So yeah, you can tell your landlord it's unlawful under the Equality Act, and you can defend the possession proceedings.
That's great. That's really helpful. Thank you. Jenny, do you have anything to add there?
Do I have anything to add? I don't think so. I think while we've been talking about landlords having blanket bans against kids, that's another thing that the Renters Reform Bill is hoping to outlaw. So that's another reason we're really pushing for the bill to come, because it's the first time that blanket bans will be directly kind of illegal rather than indirectly round the kind of discrimination and protected characteristic route. At the minute, to challenge discrimination of that nature, you would need a protected characteristic. But hopefully in the future after the bill, it will just be outright illegal to be able to put a blanket ban like that on tenant, on who can rent your property. It currently already is illegal, as Eleanor was saying earlier, but you will see on Open Rent particularly ads that say no kids and say no DSS, even still they'll say. And it's almost like letting agents and landlords don't intend to really change their habits until they're taken to task over it. So we're really hoping that the Renters Reform Bill will do something to change that.
Yeah, that's helpful. Thank you. I've just seen what the time is as well. So I have to say we are going to only have time for probably one more question. And to everyone, we've had a lot of questions, and obviously people have a lot to say on this. So I just want to say that anyone whose question wasn't answered, it might have been just because I haven't seen it, or it's a more specific nature, in which case I really encourage you to email us and we will share the question with Jenny and Eleanor and still get you a response. I just want to make sure that everyone, that we will still respond to people. It's just we are limited in time now. So I think just the last question that we'll have time for is, oh, sorry, I've just lost my page. So a gas safety certificate was done 6 months late last year, and the tenant never received the copy of it. So if this this year's gas certificate has not been done and is a month late, could a Section 21 still be issued?
Not now, before the gas safety certificate is served, but if it is eventually served, even if late, if served before the Section 21, then it could be issued. Yeah.
Thank you. Yeah. Do you have anything to add there, Jenny?
No, I was just trying to dust off some of my advisor knowledge, but no, Eleanor came to the rescue.
Okay, brilliant. Thank you. Well, that was a useful answer. And yeah, I guess that's probably all we really have time for. I did see one question as well about the Renters Reform Bill. Someone wants to know more about the Renters Reform Bill. And I have to say there's a Renters' Rights Awareness Week that Generation Rent are putting on in October, and we will have a whole webinar around the Renters Reform Bill then, and there'll be more information on that. Right now it's but coming up. And also there is the Renters Reform Coalition as well, which Generation Rent and Shelter are both part of. Is an organisation that does a lot of work on the Renters Reform Bill and has a lot of information out there on that. So yeah, I would encourage that person to look at those resources. And I just want to say thank you so much, Eleanor and Jenny, for your time and your expertise. It's been a lot to go through and a lot of very quite heavy content, so thank you so much for explaining it with so much clarity and giving us your time. And I also just want to say to everyone else, like, if you have been impacted by these issues, please do, we've got a Know Your Rights page on generationrent.org, which has a lot of information on there, and we would encourage you to of course follow the advice that has been given today, and we'll be sending out all of those resources as well. So thank you so much. And I would also just have a lovely evening, and thank you so much for joining us today. This will all be recorded. It's been be uploaded onto our website, and it will also be on YouTube. So thank you so much, and I hope you'll have a lovely evening.
Thank you.
Thanks very much.